Hello, everyone. My name is Jack Bjorn. I'm an attorney here in Pierce Atwood's employment group. I've been following Maine's paid family and medical leave program very closely ever since the law was enacted last fall, a year and a half ago. And, I'm happy to provide this presentation to all of you and try to answer as many questions as I can. I think just as we dive into the program, I will say that this is the first part of a two-part program. All the slides will be on this one slide deck and will be shared after the program next week. If anybody has any questions, again, please put them in the Q&A and I'll try to pay attention to those as we go along and answer those as I can. My goal is to provide a big overview of the program and hopefully share some resources that are available to you as well. So just going through the agenda. As I said, this is intended to be a comprehensive overview of the paid family medical leave law and rules that were finalized just a few weeks ago. The rules had three iterations, including the final rule that was published in early December. That's where a lot of this substantive info comes from, a lot of the interpretation of the law itself. So that's very helpful. In addition to that, I will kind of briefly provide an overview of the PFML website, which if you haven't gone to, I would certainly encourage that you do so as soon as possible. There you'll find a link to the portal to register. You'll also find resources such as the law itself, the final rule, comments, webinar recordings, labor poster, etc. There's also some payroll provider resources. And I'll get to some info on that later in the presentation. And then after looking at those things, I will go into some additional employer policy considerations or practice considerations, being mindful that while there are things that we want to do right now associated with this program, there will be plenty more to come in the next quarter and into next year. As we make adjustments to our employer policies and actually get ready to provide the benefits. So again, please include your questions and answers. I will try to answer those as we go along, and then at the end of the presentation, after I wrap up the final slides, probably in the next session, I'm happy to take any question and answers or provide any question and answers at that time as well. So with that, let's get started. Governor Mills signed the paid family medical leave program into law as part of the state budget last year. Maine is the 13th state to enact a paid family medical leave program, along with the District of Columbia. Under the program, beginning in 2026, eligible workers in the public and private sectors will be eligible to take up to 12 weeks of paid leave for qualified reasons. Of note, during the formation process of this program, Maine looked to Massachusetts' program, which has been in place and providing benefits for several years. So there are some similarities, some differences, which I'll also get into as well. But there are some similarities with the way that the program has been rolled out. The program will be administered by the Maine Department of Labor and covers eligible employees of eligible employers, including private businesses, the state, municipalities, and tribal governments. It also includes self-employed individuals if they so elect. Again, I'll touch on many of these details as I get further and further into the slides. The program will provide up to 12 weeks of paid leave in a quote-unquote benefit year, which may be taken intermittently in increments of not less than 8 hours or on a reduced leave schedule as agreed to by an employer and its employee. A benefit year is the year starting basically the weekend before somebody goes out on leave, and those smaller increments can only be a minimum of 1 hour. Which helps this program align with the Maine earned paid leave law if employees have hours of earned paid leave to use. Covered individuals. So here, covered individuals in the program are people who have earned wages in the state, importantly in the state, at least 6 times the state average weekly wage during the first 4 calendar quarters first 4 calendar quarters of 5 immediately preceding the first day of the individual's benefit year. Covered individuals can include individuals working full-time, part-time, per diem, seasonal, etc. This really truly covers anybody that's earning wages paid in the state. The paid family medical leave program uses the same locality test for wages as Maine unemployment law. I'll get to the locality test a little bit later on as well, but the kind of general overview of important things to know is that if you are paying unemployment insurance income in the state of Maine for an employee, generally speaking, the Maine's paid family medical leave program will apply to that individual, and those wages and contribution reports associated with that individual will also need to be made to the DOL. Conversely, if you are paying unemployment insurance taxes to New Hampshire or Massachusetts, for example, then those wages would not be considered wages in the state, and those individuals would not need to be provided those benefits. Reasons for taking leave. So these reasons for taking leave generally align with Maine's unpaid FMLA law. Those reasons include to bond with a covered individual's child or adopted child during the first 12 months after the child's birth or adoption, to care for a family member with a serious health condition, to attend a qualifying exigency, to care for a family member who is a covered service member, to take safe leave as a result of violence or sexual assault or stalking, for personal medical leave for a serious health condition, to donate an organ for human organ transplant, or for leave following the death of a family member. So here, I think one important piece to point out is that family member, both under the unpaid FMLA law as well as this program, are defined broadly. So that can include, a grandparent, for example. It also includes somebody with whom the individual has a significant personal bond, and I'll get into that a little bit later as well. So this will apply very broadly to employees and a broad sense of who their family members are for purposes of taking care of them as well. Here, one of the other things I wanted to discuss is that a serious health condition is a condition or an illness, injury, or impairment, or mental or psychological condition that involves inpatient care at a medical care center or continuing treatment by a medical care provider. So if somebody is, for example, continuing to see a mental health therapist, for example, those mental health issues can be the trickiest because they're not always readily apparent. But if they're, either in inpatient care or they're seeking treatment, perhaps sessions that are weekly or biweekly, this paid family medical leave program could provide that individual paid leave in order to go to those sessions on an intermittent basis, for example. Notice. With respect to notice, absent emergency illness or sudden necessity, employees must give reasonable notice of their intent to use leave. Notice must also be scheduled to prevent undue hardship on the employer, as reasonably determined by the employer. And Maine is the only state with a paid family and medical leave program that has an undue hardship provision. So just breaking down the slide a little bit, reasonable notice, 30 days, generally speaking, will constitute reasonable notice. I think the emergency illness or sudden necessity provision piece of this is supposed to align with Maine's earned paid leave law, which provides essentially the same exception and essentially the same notice time frame. With respect to the undue hardship provision, this is something that I'll get into in more detail later in the program as well. but is probably the biggest differentiating factor between Maine's program and other state PFML programs. And I do think will provide an employer an ability to try to work around an employee's needs in taking leave, but also say, like, there may be times that an employer can't have one employee in a 5-person business, or the CFO of a much larger business, or whatever the case may be out during a specific period of time, whether that's a busy summer season, for example, or tax season if the person is crucial to the finances of the business. So there will be a way to kind of discuss that with the employee and the DOL and find a leave schedule that works for both the employer and the employee. Just going to try to take a couple of these questions as we're moving through the slides. Here, the first question is, we have successfully registered on the state portal, which is great. I'll get into that a little bit more as well. How do we now set up a payroll provider as a third-party administrator? On the portal itself, you can go on and I think once you are logged on, there is a designated spot to add another recipient email or another provider, and then you can select that as a third-party administrator. There's also a webinar available on the PFML website, which will walk you through exactly step-by-step where to include that as well. Another question is, you mentioned that they are 12 weeks following a benefit year. Is that the same as a rolling method? Essentially, yes. So if you for example, went out on family leave on March 1, for example, the benefit year would start then and roll through the next 12 months. And then you would be eligible to take an additional 12 weeks of leave starting, the next March 1st, or the applicable start date, starting the weekend before. Can you talk about undue hardship with leaves that are also covered by FMLA? Yes, I will definitely do that later on in the program. That's definitely one of the considerations, and how this program will interact with unpaid federal or state FMLA. So I will definitely get to that. And can employer ask someone for some kind of documentation to show a significant personal bond? Yes, the DOL itself will provide documentation. The forms, as you are probably aware, are not published yet. Basically any form for the program, but those forms will include requests for substantiating the family relationship, and I'll get into that a little bit later as well. Employee rights. Taking family and medical leave may not affect an employee's right to accrue vacation time, sick time, bonuses, advancement, seniority, length of service credit, or other employment benefits plans or programs. Notably, employers cannot compel employers to exhaust rights to any sick, vacation, or personal time prior to or while taking leave. This is a big difference between unpaid FML in both the federal and state context. So here, if you are going out on leave, an unpaid leave, let's say today, for example, prior to the benefits being paid under this program, an employer could require an employee to use whatever PTO time that they have available for the first 10 or 12 weeks, depending on which FML is applicable. Under the paid family medical leave law, employees have a right to take the leave and then also take at some other time their PTO or sick time or vacation time, or whatever the case may be. Employers can allow employees to supplement their leave benefits with sick, vacation, or personal time as may be appropriate under the circumstances. So here, again, if an employee is not getting their full wage replacement, which they won't, one thing that an employer can do to kind of get them up to their full wages would be to allow that employee to take however many number of hours of PTO that would be equivalent to their wages to get up to that 100% threshold. Employees that have been employed for 120 calendar days are entitled to be restored to the same or equivalent position with equivalent pay, benefits, and other terms and conditions of employment. I think one thing that's important to note here as well is that the 120 calendar days can toll, any, or if somebody goes out on leave during those 120 calendar days, can toll any probationary period. So say, for example, an employee starts employment and 2 weeks later has to take leave for some applicable reason and they're under a 90-day probationary period, then the 90-day probationary period can continue throughout an intermittent leave schedule or can continue once the employee returns to work. All right, so with respect to program funding, the program will be funded by an employer and employee premium payments that begin on January 1 of this year. So 8 days ago. Premium payments made by employers and employees may not be more than a combined 1% of wages. Notably, employers with 15 or more employees can deduct half of that premium from an employee's wages, but are responsible for remitting 100% of the combined premium to the benefit fund. So put in other terms, of the 1%, the employer with 15 or more employees will have to pay in their 0.5% contribution. Employees can pay in their 0.5% contribution, but the employers themselves are the ones that are responsible for making sure that those contributions are actually paid to the state on a quarterly basis. Conversely, employers with less than 15 employees do not themselves have to pay a premium because they may deduct that premium responsibility from the employee's wages. Again, however, they are responsible for remitting that amount to the fund. In all cases, an employer may pay the employee portion of the premium and can pay some portion of that. It doesn't have to be the full 0.5%. It could be 0.3 or 0.2, and then the remaining amount can be paid by the employee as well. That is all dependent on the employer, but employees themselves can only ever pay 0.5% of their wages into the program. With respect to the benefit formula, the benefit formula is a little confusing, but all goes back to the state average weekly wage. Again, this program is intended to provide benefits that will not cover an employee's total wages in any case, and the benefit formula that ultimately spits out how much money the individual will get in their benefit is capped at the state average weekly wage, which is set on July 1 of each year. So currently that's a little over $1,100 as of July 1 this past year. That will get re-upped this coming July, and then next year when benefits begin being paid, it will be re-upped again. The formula will stay the same, but the state average weekly wage will presumably increase, and therefore the max amount of benefits can increase as well. So another question I get before going too much further is an employer responsible to provide employees anything they need to sign for the tax deduction? Great question. So just kind of I'll go back a slide so we can look at the withholdings piece. The short answer is no. An employer does not have to have the employee sign anything, but they do have to provide the employees with notice, which I'll get to in a little more detail. There are some nuances to that as well, but there aren't any specific forms. Is an employer required to bargain over the Maine paid FML if requested to do so by a union? Great question. One that I wish that I had the answer to definitively or in writing, but I do not. I will get into the differences a little bit as well between public and private employers a little later on with respect to unionized employees. But so far, there's no definitive guidance on whether or not an employer has to bargain. But I would suspect, based on the NLRA, that they would, even if the guidance says perhaps otherwise in the future. Can you require people to use PTO concurrently with PFML the way that we do with FMLA now until it is exhausted? Again, the answer to that is no. An employee is able to keep whatever PTO or vacation sick time that they have and can use it at another time, but they can supplement their PFMLA benefits with such time. And then does this mean that employees are still able to accrue PTO while out on PFML? If they are not working, then you can accrue other benefits, but if you thinking about the earned paid leave law, for example, here in Maine, you would not be working, and therefore you wouldn't be eligible to accrue any additional time on top of whatever time you've already included before you go out on leave. However, not all leaves are on a 10-week or 12-week basis or run for any full period of time. They can be intermittent, so an employee may be able to accrue their other benefits if they are taking leave on an intermittent basis or a reduced leave schedule, for example. With respect to program administration, the DOL will provide procedures and forms for filing claims. Again, none of these forms have been published to date, at least to my knowledge, as of this morning. I think so far the DOL was simply busy with putting the rules in place and getting the portal live so that employers can register and get the program up and running. I would expect that many of the forms related to applying for the program itself or applying for benefits will probably come next year, whereas some of the other forms with respect to private plan substitutions presumably will be published here in the next couple months. The law also establishes a benefit fund to be administered by the state treasurer, and the fund must be used for the exclusive benefit of covered individuals and to cover the admin costs of the program. So what this is saying is essentially all premiums that an employer or an employee pays will go into this fund, and all of that money has to be used exclusively to pay those benefits in the future or to cover the admin costs of the program. Admin costs by law may not exceed 5% of the amount deposited in the fund each year, and there will be a study done each year regarding claims experience and admin expense and target fund requirements to make sure the fund remains solvent. Notices, as I had started to say, employers must provide notice of the benefits in the form of a poster in each of its premises. Notices must be posted in English and each language other than English that is the primary language of 3+ employees of that workplace. Here, for the time being, notice can come in the form of the DOL labor poster that's available on the PFML website that provides a general explanation of what the program is, the benefits that will be provided, and the withholding or deductions that can come out of an employee's paycheck. Additionally, supplemental to that notice poster that should go up right away, employers must also provide written notice to each employee not more than 30 days from an employee's start date. And that notice has to include an explanation of availability of the benefits, the employee's contribution amount, the contact information for the employer and the program administrator, the identification number assigned to the employer, which I believe you're assigned when you register for the portal, and instructions on how to file a claim. So here, some of this information still needs to get worked out. As much as there is information out there that helps us understand how this program is starting, a lot of the actual moving pieces will still get figured out over the coming months and the next year. I think importantly, if you have an employee start tomorrow, a good place to start is providing a copy of the labor poster for them to understand what the program is and how it will be administered. You can also inform them about their withholdings from their paycheck, whether that's the full 0.5% or whether the employer is covering that 0.5%, or for example, if the employee is responsible for paying 0.2 or 0.3 or 0.4 or whatever the case may be. Elective coverage and other plan options. The law also provides options for self-employed individuals and tribal governments to elect coverage with specific periods of coverage and notice of election requirements. It also permits employers to apply for a private plan substitution. That includes either through a fully insured or self-insured plan. And such plan must offer the rights, protections, and benefits that are substantially equivalent to those provided under the state program. I will get into some of those details later on as well. Employers that fail to provide notice will be assessed a penalty of $50 per employee for the first violation and $150 for every subsequent violation. So with respect to providing notice in the form of the labor poster or notice to the new employees, you do really want to start doing that immediately for any new hires or for the people that are already working at any place of business. Tax treatment. So this is, I've been doing these presentations for the last year and a half or so. This question has come up at every single one, and at every single one, I have not been able to provide any good tax guidance. And that is because so far, there is no available tax guidance. The DOL has deferred to the IRS and the Maine Revenue Service for tax treatment of the program. The one thing I can say is that the premium benefit amount, if you want to consider that a tax, is to be determined on a whole wages basis. So, for example, easy math: if somebody is earning $100,000 a year, their 0.5%, if you want to have them pay, would be $500 a year. So before any other taxes or deductions are taken off their total wages. The other thing I'll note is that this past spring, in 2024, the Maine Department of Labor met with the IRS, who had said that they plan to provide guidance to Maine and the other states that have paid family medical leave programs by the end of the summer. We are obviously in January of the following year without any guidance, but my hope certainly is that we will have some additional guidance by the time the benefits begin being paid next year. So to be determined, and certainly we will provide an update to all of you once any guidance is published. So just getting to a summary of the important dates. Again, last year, the law was passed in October. This past January, the Maine Department of Labor began the rulemaking process. January 1 was the date that the Paid Family Medical Leave Act required that the DOL implement the program rules. Those rules have now been finalized. This past January 1, employer-employee contributions to the program begin. So if you haven't started withholding those employee premiums, you'll need to start doing so. On January 6th, the Maine Paid Family Medical Leave portal also opened. In addition to the portal opening, the designated phone line with the Department of Labor opened the same day. My understanding is that they're fielding a lot of questions, mostly with respect to registration, but if you have other PFML specific inquiries, you can call and ask, and somebody will be able to answer the phone and hopefully answer those on the spot, or provide an answer to you within a couple days. Starting on April 1 of this year, employers can apply for a private plan substitution. Again, I'll get into those details a little bit later on. April 30th of this year, the first quarter premiums are due. Those contributions are due, as well as the contribution reports. And then beginning in May of next year, claims for benefits begin being processed. as noted in the law itself, May 1 is the anticipated start date, but the program authority also has the ability to provide a one-time suspension of claims no longer than 3 months, effectively delaying the payments until August 1, 2026. So far, there's no indication that that's going to happen, but that is all dependent on the fund and how much is contributed and like the ability to actually begin paying benefits to everybody that applies for claims when the benefit portion of the program starts. With respect to the final rule, on December 3rd, I believe, the Department of Labor released its final rule regarding the paid family medical leave program. The DOL continues to update its FAQs and provide other resources as the program again begins. Those resources again are available on the paid family medical leave website. The final rule is the product of a year-long rulemaking process that included 3 iterations of the rule, each with its own respective comment period. Those comments or a condensed version of all of the comments that were submitted is also available on the paid family medical leave website, but that was intended to allow employers and employees and interested parties to provide an input into this rulemaking process. And there certainly were adjustments made along the way that I think are beneficial and are helpful in clarifying how this program would be administered in the months and years to come. Some notable definitions that were included in the final rule. One of those is good cause. This applies to a handful of the different provisions in the rules itself, and includes a serious health condition that results in a period of incapacity, an inability to file an application due to a natural disaster, a serious health condition of a family member that requires an unanticipated prolonged absence of the individual filing the application, physical, intellectual, or linguistic limitations preventing timely application, or other circumstances beyond an individual control. Good cause will be determined at the discretion of the Department of Labor, and keeping in mind that if at the end of a period to apply for leave, for example, that there was a huge winter storm like one of the ones that we had last year that knocked out power to a region for a period of time, that might qualify. If somebody was having difficulty understanding what the program requirements were or what the application requirements were because of the language that they speak, for example, that might also qualify. So again, that's in the hands of the Department of Labor to determine good cause, but there are a handful of time requirements that can be waived for such examples. Wages. Wages includes all remuneration for services performed in the state or wages which are otherwise subject to the Maine unemployment tax. That includes tips, gratuities, severance and terminal pay, commissions and bonuses, up to the Social Security taxable wage base, which for this coming year, I believe is approximately $170,000 or $175,000. So again, the vast majority of employee wages paid in the state will be covered by the program, and premiums will be due on those wages. Employees that are not covered in the program include railroad employees, incarcerated persons, students earning wages as part of a federal work-study program. Of note there, wages that a student might earn on campus as part of a cafe job, for example, or a library assistant that are not specifically designated federal work study would be subject to the premiums and withholdings, and those employees could be covered for that work as well. Employees not covered also include volunteers for an employer or a governmental entity if the individual performs a service for charitable purposes, without promise or expectation of payment. The individual offers the services freely, and the individual is not otherwise employed by the same employer or governmental entity to perform those same types of services. Notably, the individual may be paid expenses or reasonable benefits or nominal fee to perform such services. So here, for example, if an individual was on the board of a nonprofit and the board of the nonprofit paid the individual's travel expenses to attend a meeting, for example, that could qualify as a volunteer, and therefore that person would not be considered a volunteer, or excuse me, an employee that would be covered by this program with respect to that service. Employees not covered also include employees of the federal government. Types of leave and restrictions. Individuals can take continuous, intermittent, or reduced schedule leave, and partial days or weeks will be prorated against an employee's scheduled work week. As I've noted, individuals can take leave in increments of not less than a scheduled work day, unless agreed to in writing with an employer, in which case the minimum increment is 1 hour. Payments will be prorated based on hours of leave used divided by hours of work scheduled. And if the individual's schedule varies, the hours worked is determined based on an average number of hours that the employee has worked in the previous 12 weeks. And an individual's leave will be reduced for any leave taken under the federal or state unpaid FMLA in the 12-month period preceding the start of the leave. I want to take a second to just pause and kind of break down this one a little bit, provide a couple of examples that I think are important to understanding the bigger picture. Of course, there are employees that don't necessarily work just one job, that might work multiple jobs. So working out a leave schedule is between that employee, the Department of Labor, and one or more employers. If leave is on an intermittent basis, for example, maybe an employee needs to take a week off every other week for some medical reason, for example, that is permitted. Or if an employee needs to take Fridays off, or some other day of the week off for treatment for a serious medical condition, that could constitute a reduced schedule. And an employee will be paid benefits based on that reduced schedule. With respect to the way that this program will work with federal or state unpaid, the Department of Labor has also said in its webinars that it does intend to look at whether it will provide a look-back period. What that look-back period looks like certainly is unknown at this point, but the Department of Labor has indicated that a 3 to 6 month look-back period for provision of benefits may be applicable, as that is something other states have done when they've rolled out their own programs as well. Notice and undue hardship. Again, absent the emergency, illness, or sudden necessity, employees are required to give reasonable notice. 30 days is presumed reasonable. When notice is given, it must be written, and it must include the reason for the leave, the type of leave, the timing and duration of the leave, and any other information regarding an employee's need to take the leave. Here in Maine, the application for leave will go to the Department of Labor, who will then contact the employer and work out the rest from there. So the Department of Labor ultimately will be the one at administering the leave and coordinating the leave schedule between the employee and the employer. Employers and employees can also agree to a leave schedule, in which case the employers can waive the 10-day review of undue hardship. So in the case of an undue hardship, that employer would make that claim to the Department of Labor, who will then analyze the employer's determination of the undue hardship. An undue hardship means a significant impact or a significant expense of the employer or on the employer, considering the financial resources of the employer, the size of the workforce, the nature of the industry, that cannot be overcome with any amount of notice given. An employer's determination of the undue hardship will be considered reasonable if the employer provides a written explanation of the undue hardship to the employee, demonstrating that significant impact on the business. The employee retains the ability to take the leave within a reasonable time. The employer made a good faith attempt to work out a schedule for leave that meets the employee's needs. And then if medical leave is requested, the employer's proposed schedule is sufficient to accommodate the healthcare needs of the employee and the judgment of that employee's healthcare provider. So kind of breaking this down a little bit further, this is a little more friendly to the employers than the rules or the initial proposed rule that was provided last spring or proposed last spring. Here, again, this framework, this rule framework, allows an employer to say that no, during this 3-week period of the year, this is our busiest season. We really need you to work during that time. Can we work to find a different schedule, a reasonable time that you can take your leave for this reason? And if we can, then the employer schedule will prevail, all other things being equal. That being said, the caveat is this last bullet point with respect to the healthcare provider. So if a healthcare provider says, no, this individual needs to have their cancer treatment start right away, an employer likely will not be able to claim an undue hardship with respect to this employee where the healthcare provider says that this person needs treatment immediately versus can schedule a surgery at some later date and then schedule the leave period at a time that's not so difficult for the employer. With respect to benefit reductions, so benefits when they begin being paid will be reduced by wage replacement from unemployment insurance, workers' comp, other than for injuries occurring prior to a leave claim, other state or federal temporary or permanent disability laws, emphasis on the law, or from an employer's permanent disability program. However, benefits will not be reduced by benefits from SNAP, TANF, HEAP, or other similar programs, wages from another employer, wages from the same employer for hours worked or authorized, wages from the same employer if the employer voluntarily pays the difference between an employee's benefit and the amount of the typical weekly wage, or supplemental payments from the employer's short-term disability policy, provided that the total payments do not exceed the individual's typical weekly wage. Again, just a couple of quick examples. It is very possible that, like on an intermittent basis, an employee that works for a single employer might need to be out of work 2 days a week for some stretch of time, and the benefits that they receive will only be based on those 2 days a week that they are out of work on leave, and the benefits will not be reduced by payments that they receive for the other 3 days that they are still working, for example. Another point to note is that this last little bullet point about the short-term disability policy is a change that was made in the final rule itself that I myself and others had commented on throughout the rulemaking process to align this program better with other similar paid family medical leave programs. And this simply caps the benefit at some combination of paid family medical leave benefits and short-term disability without going above 100% of wage replacement. So somebody can't collect a double benefit, for example. With respect to premium payments, premiums must be submitted quarterly on or before the last day of the month following the close of the quarter in which the premiums have accrued. So using this period as a great example, for this first quarter, the premiums must be submitted on or before the last day of April. So April will be a big month for many of you, especially those that intend to apply for a private plan substitution, and any reports or premiums will be due during that period. Premium payments will be made timely if they're postmarked or received electronically on or before the due date. So if you sent in your premiums, perhaps you're a small business and you sent in your premium payments by mail on April 30th and they're postmarked on April 30th, they will be considered timely even if the DOL receives them, several days later in May, for example. After an employer registers for the portal, an employer can assign a TPA to submit the reports on the behalf of the employer. Again, there are specific instructions that are provided in a very easy to understand, easy to follow quick video on the Department of Labor PFML website if you want to assign a TPA to submit those reports on your behalf. Also of note, I know I've mentioned this several times before, and I probably will continue to do so, but premium withholdings began on January 1 of this year. So if you are an employer with employees and you intend to have those employees pay their share of the premium, then those premium withholdings need to begin now. For contribution reports, wages must be reported to the nearest cent, and premiums must be reported to the nearest dollar. If there is an overpayment of premiums, employers and employees can request a refund of that overpayment. For purposes of determining an employer size for premium liability, that happens on October 1 every year for purposes of the employer size and paying premiums the following year. So here on October 1 of every year, any employer that employs 15 or more covered employees per that employee's federal EIN on their established payroll in 20 or more calendar weeks preceding September 30th of every year will be considered an employer with 15 employees. This includes part-time, full-time, per diem, other employees that are on paid sick leave or paid holiday, or some combination of the two, that would be reported on that employer's payroll in those 20 or more calendar weeks. So if anybody has any questions on that, I'm certainly happy to answer those, before or after, or during or after the program as well. Premium payments continued. An employer's decision whether or not to deduct premiums from employees' wages must apply to all employees, with the exception being for employees in separate collective bargaining agreements. So if you make a determination that you do want your employees to pay their 0.5%, that decision will have to apply to all employees, not just the full-time employees versus part-time, or not just high earners versus low earners, or like executive staff and some other employees. However, if you decide that you only want those employees to pay 0.2 or 0.3% of their wages and you'll cover the rest, that's totally fine, as long as you are making that determination and applying it to all of those employees. The exception here is a big one, because if you are an employer for that has multiple collective bargaining agreements, for example, with different groups of employees, those different bargaining agreements can provide that the employees pay different amounts of the premium, provided that those employees in any of the collective bargaining agreements do not pay more than half of their percent of their wages. If an employer decides to change the premium withholding amount, it also must notify the employees in writing at least 7 days before the first affected paycheck. So say, for example, you decide now that you're paying the employee premiums, and you do so for the first 6 months of this year, but then you decide, based on finances or for some other reason, that you instead want the employees to pay their portion of the premium. You have to give those employees notice in writing at least 7 days before their next paycheck. Deductions can be made no less frequently than quarterly. So typically the deductions will happen on a paycheck by paycheck basis, but you can agree in writing with an employee to have those deductions taken out from the last paycheck of the quarter, for example. If an employer fails to deduct the premiums, the employer must pay that employee share of premiums. So if, for example, you have not collected premiums to date, starting on January 1 of this year, you would be responsible for collecting those premium or paying those premiums for this pay period. You would give notice to the employees that you intend in the next pay period to start making those deductions, and then you'd be okay from then on out. Employers that fail to remit the premiums are subject to a penalty of 1% of total wages for the quarter, and shall be liable for any of the benefits paid to individuals for whom the employer failed to make premium contributions. So this is a pretty significant penalty, depending on the finances of the employer, the size of the employer. So it will be really important that you are timely submitting those premium payments every quarter. And if you don't do so, and for example, you had 3 employees that go out on leave during that time, you would then be responsible for paying those leave benefits allocated to those employees, as well as the 1% of total wages for the quarter. So this penalty can grow very quickly. The DOL will provide notice to employers of any delinquent contribution reports, and employers will have an opportunity to correct those reports. Having said that, the best practice is to get them correct initially. But if the DOL spots something in a contribution reports that maybe it was off by a few dollars or whatever, the DOL will provide notice of to the employers and an opportunity for them to correct that report and resubmit it. Self-employed individuals and tribal governments. I believe there are a handful of self-employed individuals on the call. So this is definitely geared toward you. Self-employed individuals and tribal governments can elect coverage under the program, which shall be for an initial period of 3 years, renewable in 1-year increments. Wages for the self-employed are based on net earnings from all self-employment, including but not limited to income reported to Maine on the personal income tax return from a prior tax year. Applicable tax returns must be submitted to the DOL by 6/1 every year, and those would determine your net earnings for the following year. Self-employed individuals and tribal governments can withdraw from coverage within 30 days from the end of the coverage period, and the DOL will notify individuals of the end date of that coverage within the 60 days of that end date. If anybody has any specific questions geared towards self-employed individuals, I am happy to answer those on a one-on-one basis, as there are specific notice requirements and election requirements that are applicable to these groups of individuals. Private plan substitutions. I see that we're kind of approaching the end of this first session. I do have about a third of the presentation left with some room to answer questions. I will just in advance start touching upon the private substitution, but we'll probably regroup because I know this is a really hot topic for many employers in the state when we start the next session next Wednesday at noon. So for those that are interested in a private plan substitution, employers can request to substitute a substantially equivalent fully insured or self-insured plan instead of using the program. Applications can be submitted on or after April 1 of this year, and substitutions must provide for coverage for all employees within that employer's FEIN. There's an application fee of $250 when you go to submit the application, and there's also another $250 administrative reimbursement fee if the substitution is approved. Those fees may be increased on the 1st of next year or thereafter based on inflation or the cost of administering the program. So certainly if you are intending or thinking about using a private plan substitution, I certainly would encourage you to make that application sooner rather than later, because that will only financially benefit you with respect to the premium payments or the application fees if those are increased next year. Substitutions are valid for 3 years. And the exemption from the obligation to pay premiums begins on the first day of the quarter in which the substitution is approved, unless the application is submitted less than 30 days prior to the end of the quarter, in which case the exemption is effective the next quarter. Here, another big important April deadline for those that are intending to provide private plan substitutions. If you do intend to do so, I would encourage you to apply right, within the first month, within April, if you can. Do not apply towards the end of any quarter unless you are prepared to pay the premiums for that quarter. So here, if you applied from April 1 through May 30th, for example, the effective date of that substitution would go back to April 1, in which case any obligation to pay premiums would end on April 1, and you'd only be responsible for paying premiums for the first quarter. But if you applied after May 30th, the exemption would be effective the next quarter, and therefore you would also be required to pay premiums for the second quarter as well. If employee withholdings were made prior to the approval, the employer must refund those withholdings back to the effective date of the exemption within 30 days of the approval of the substitution. So again, if you continue to withhold through the end of April and maybe you applied for the substitution on April 30th, which was subsequently approved, your effective date of the substitution would go back to April 1. But you would be required to pay back those premiums that were withheld to those employees within 30 days of the notice of approval. The employer still is responsible for the premiums provided under the Act until the effective date of the exemption, and premiums paid prior to the effective date must be paid and are not refundable. So what this is saying is simply any premiums that are paid within this first quarter until you have the opportunity to apply for a private plan substitution are non-refundable. I think with that, this provides a good jump into the private plan substitution discussion that I'll continue next week, definitely including the highlights of what you need to know right now when you're considering whether or not to apply for a private plan substitution. And then next week, we'll get into a little more detail on this, some of the resources that are available, as well as the impact of this program on unionized workforces and impact on current employee or employer policies. So thank you. If you have any questions between now and Wednesday, please feel free to reach out to me. My contact information is right here. So jbjorn@pierceatwood.com. If you already have a contact at the firm, I welcome you to reach out to them and they can direct the questions to me as well. And hopefully we'll keep everybody as prepared as possible as we work through this first quarter and get ready for benefit payments next year. So with that, thank you very much for attending today's first session, and I will look forward to seeing you all next week and answering any additional questions next week as well. Thank you very much.